Good evening and welcome to the John Marshall Law School for the Federalist Society. We're here today to discuss Gundy versus the United States, the most significant case on the Delegation Doctrine in 85 years. We'll be joined by Mr. Graziano. I'd like to just take a moment to say welcome to the Federalist Society members. Those of you who have not yet joined or who are students of John Marshall, I encourage you. And if you are interested in board positions, come this fall. I will be stepping down as president, and Mr. Joseph Dusek will be taking over. It's nice to announce that first and foremost. And then once again, if you're interested in board positions, they are available and will be. So I'm going to let Mr. Dusek talk a little more. Thanks for attending.
All right, thank you all for coming out tonight. And I think I'm just going to turn it over to Todd. Get it rolling. We have some exciting events planned for the spring, so stay on the lookout for those in your email. Keeping abreast of current cases before the Supreme Court. Remember, the Federalist Society is primarily an intellectual organization, and that's our goal tonight, to learn from this gentleman. Come on up, please. Thank you so much for coming.
I want to thank the John Marshall Law School Federal Society for inviting me and organizing this event, especially to Joseph Dusek for all the arrangements he made. And I also want to welcome the folks viewing this on public access TV. My name again is Todd Graziano, and I'm currently the Chief of Legal Policy and Strategy at the Pacific Legal Foundation. And as I told a few of the audience members beforehand, we've already won 2 Supreme Court cases for our clients this year, and we already... Thank you. And we argued 2 more the first week of October, which is the day before and the day after the case I'm going to talk about. Most people think that this case I'm going to talk about, Gundy versus United States, is the most important case of the term, but any case for our clients is the most important case. But I'm wearing a tie that relates to one of our Supreme Court victories this spring, so if you have a question and you don't want to ask about non-delegation, I can talk about that as well. But the primary topic of my prepared remarks, and I'm going to talk about 25 minutes or so and then welcome your questions, is about the non-delegation doctrine. And the non-delegation doctrine, for first years who haven't studied it yet, or people who aren't lawyers viewing it on public access TV, is a rule of constitutional law that prohibits Congress from delegating its lawmaking power to the president, a federal agency, or any other person. Now, it's an absolutely critical and vital constitutional rule. In fact, I think it is the most significant rule of the separation of powers. And the separation of powers was designed by the framing generation to protect our liberty. Now, reasonable people might differ as to whether it's the most important principle of separation of powers law, but no one disagrees that it's vital and essential. So I will read you 2 quotes from the canonical case from the late 1900s that involved Marshall Fields, which still sort of exists under Macy's rubric a few blocks away. So the Supreme Court majority said this, that Congress cannot delegate legislative power to the president is a principle universally recognized as vital to the integrity and maintenance of a system of government ordained by the Constitution. So it's absolutely vital to the maintenance of our Constitution. Well, the dissent in the Marshall Field case by Justice Harlan certainly agreed on the principle. So both the majority and dissent agreed on the principle. So this is from Justice Harlan. Quote, that no part of the legislative power can be delegated by Congress to any other department of government, executive or judicial, is an axiom in constitutional law and is universally recognized as a principle essential to the integrity and maintenance of a system of government ordained by the Constitution. So the rule that Congress can't delegate its lawmaking power, everyone agrees is essential. And though that is an old case I quoted from, it's still being quoted today, and it's still good law. There's only 2 issues as far as the court is concerned, and they involve the application of this rule. And one application issue is, okay, what is the core lawmaking power that Congress can't delegate? How much, in other words, can it leave to the agencies to fill in? And that's an important principle because we all must concede that most laws are not self-executing. Most laws do have questions that arise. And interpretation, either by the executive or a court, does involve filling in gaps. But when I was in law school in this city, 33 to 30 years ago, I remember my professor saying the project of constitutionally filling in gaps was interstitial gap filling. Interstitial is a word I looked up, means the space between grains of sand. So small gaps. That's what was expected of enforcement of laws. So Congress has to do the major work of defining what the law means, but there's inherently going to be some open questions. And if you're a law student, you're tortured by them, particularly your first year. The second issue is what role should the courts play in enforcing that essential rule? So starting in about the 1940s, almost to the current day, but we're having a re-examination now, several justices maintained, oh yes, even one of my heroes, Justice Scalia, got this partly right and partly wrong. He said, oh yes, it is absolutely essential. This principle that Congress can't delegate is absolutely essential, but we in the courts, and they would wring their hands, may not be able to come up with a manageable standard. We're very worried and we'll come up with a very deferential standard. So starting in the 1940s, well, the test that is supposedly applies to govern whether Congress is unlawfully delegating its power or not was first instituted in 1928 in a case called J.W. Hampton. And J.W. Hampton was actually a case where the executive branch was supposed to make some economic determinations about costs and prices and customs duties. And I think that kind of delegation would have been okay under any test. But the test they created is called the intelligible principle test. And without quoting the exact language, the court said as long as Congress delegates to the president or an executive agency an intelligible principle for them to work on, then it's constitutional. Well, I submit, and many people submit today, that is too lax a test. The rule in the Constitution is that Congress can't delegate its lawmaking power. There's no exception for delegating its lawmaking power if it gives the agency an intelligible principle. But at least the injury with the intelligible principle test wasn't complete, because at least they did strike down a few laws. Since 1789, the Supreme Court has only struck down 2 statutes under the Delegation Doctrine. Both of them were in 1935. The case that is, the statute that's under consideration now, the Sex Offender Notification Act, and the particular provision at issue that delegates to the Attorney General some unguided power, I think will be the third such case. Because I think the court, and I'll try to explain why, believes it's gone too far in not policing this essential constitutional line. So I think the major error from 1940 in applying that standard was that the courts began to apply even that loose standard in a much more lax and even in a ridiculous manner. So among other things, the Supreme Court in the 1940s said that if the law doesn't provide an intelligible principle, look to the purposes, look to the legislative history, and think to yourselves, if you were a judge, could you not find some sort of principle that you could say is intelligible if you look through an legislative history or purposes? So the Supreme Court kept reversing courts that would question delegations, and finally the lower federal courts by, let's say, the 1990s got the message. And the message from the Supreme Court was anything goes. Make it up. What we had particularly from the 1940s on, is Congress passing hundreds of statutes. It could have been more specific. It could have done a better job. Some of the intelligible standard in many of them was in the public interest. So for example, the FCC, Federal Communications Commission, by one study, has at least 100 provisions in law where it's given some power to do something, and the only standard Congress has given it is in the public interest. Well, the same provision in the public interest allows the FCC to regulate the internet. The same provision allows it to reverse what the previous commission did. That's no standard at all. Another example that I want you to consider is the OSHA statute. OSHA, of course, is in charge of protecting workplace safety, except that OSHA is given an unconstitutional delegation, or at least I believe it's unconstitutional, and some liberal scholars, including Obama's own head of regulatory affairs, Cass Sunstein, questioned whether it was constitutional. So Congress gives all its lawmaking power over worker safety to OSHA. It's like Congress has delegated 100 mini Congresses. They're all in the executive branch. But to OSHA, it's given all its workplace safety authority, and it says it may issue any workplace safety standard it wants, and it doesn't have to, which is even worse, as long it can issue whatever workplace safety standard and here's the intelligible principle, that's necessary or appropriate to workplace safety. So what isn't appropriate? I mean, how can a judge, so let's say I challenge OSHA's latest standard on ladders. Well, OSHA says, well, it was appropriate. Well, how's a court supposed to say it wasn't appropriate? Congress needs to do a better job. And so what we have seen based on the court's abdication is a situation where Congress now has an incentive to pass feel-good laws and then put the responsibility on the agencies. And then it can sometimes blame the agencies if the agencies go too far or don't go far enough, or sometimes both. And sometimes the same member of Congress will say they went too far but not far enough, or different. So Congress isn't doing its job. Now, why is this constitutional rule? Why does it exist? Let me go back to the framing generation. And let me tell you why it's important, not only that we gave Congress the lawmaking power, but we didn't allow redelegation. Well, in the first sentence of Article 1, Article 2, Article 3, we the people vested different power in each branch of government. So the first sentence of Article 1 is the vesting, known as the vesting clause of Article 1. We the people vested all the lawmaking power in Congress. So it's clear that no one else has any to begin with. Now some smarty pants might say, well, okay, we vested it in Congress, but they can redelegate it. But no, we made it very clear. We made it very clear that that can't happen. One principle of law that's a background principle that a professor named Gary Lawson correctly pointed out, and that John Locke even acknowledged before the framing generation, was that when any principle confers a power on an agent, a significant power on an agent, it is presumed that the agent can't redelegate it unless the principle said expressly that it can be. Well, John Locke said exactly that. And we understood, we fought a revolution to take John Locke's theory to the next level, but John Locke essentially said the same thing. The legislative power, Parliament can't give the legislative power away. They are elected, we require them to do the lawmaking. But there's lots more evidence in the Constitution that we expected Congress to keep the lawmaking power. The debates over the Constitution and the ratification debates in the states make the following clear. The framers thought the lawmaking power was the most dangerous. And because they thought it was the most dangerous, they put a lot of other provisions in the Constitution to guard against its abuse. One, we gave it to the branch that's the most directly politically accountable. Second, we fractured the power. We fractured the power because lawmaking requires near simultaneous agreement between the House and the Senate. You can't have the House passing something 30 years ago and the Senate picking it up. No, there needs to be near simultaneous agreement in a Congress on a bill, exact language of a bill. It then must go to the president. The president then has a very short period of time to approve it. He must approve it, or it must be repassed near simultaneously by both houses. Not only that, but different elements would act on those three officers. So those three entities, I should say. House members have small districts. Senators have whole states. The president has the whole nation. House is elected every 2 years. The president every 4. The Senate staggered 6-year terms. All that it wasn't an accident. They didn't just pick these numbers and pick these ideas. They explained what they were doing. They were trying to defeat factions and special interests. And the system they created, which is the greatest constitution in the world, doesn't allow our government to act quickly as some other governments, but it has the following virtue, which I think outweighs swiftness. The British Parliament, anytime there's a majority, they can enact whatever they want, and there's some advantages to that. But the advantage of our system is that legislation, which was thought to be the most dangerous potentially dangerous to our liberty, but necessary in certain ways, requires a high level of consensus, compromise, agreement, public debate. It was supposed to be rare. So if Congress were allowed to give that power away, even if it did it by subject matter, okay, we'll give all the environmental law to EPA and all the worker safety to OSHA. We're going to give, all the labor law to the Labor Department, and we're going to wash our hands of it. It destroys all of the protections the framers put into the clauses of the Constitution legislation. I'll add one other. There's several others, but the origination clause says that tax legislation must originate in the House. But under modern theories, progressive theories of the administrative state, well, Congress can even delegate the taxing power to some agencies. And they can decide for themselves how to define the law, how to enforce the law. We're just going to do it in a broad manner. So that is the state of the world we've been living in for a number of years. And Halloween, we're here to discuss whether the delegation doctrine is barely alive, whether Congress will drive a stake through its heart, whether it could be animated like Frankenstein. No, it's a good Frankenstein, like a good Frankenstein, and come back and do some work. And so I'm going to now turn to the case before the Supreme Court and why I'm optimistic that it'll at least start to revive the delegation doctrine, start to revive serious policing of the rule that Congress can't delegate its lawmaking power and actually has to do the hard work itself. The Congress passed the Sex Offender Notification Act, which requires sex offenders to register at the federal level, but it couldn't decide whether, and that applies, by the way, whether you're convicted of a state offense or a federal offense. But they couldn't decide. Congress couldn't decide whether to apply it to people who committed and were convicted of a sex offense before the act was passed. The House wanted to apply it. The Senate wouldn't agree. So they put in this provision. The Attorney General decide. They gave no guidance as to how the Attorney General was decide. They just punted. So in this case, Mr. Gundy committed a sex offense before the act, but he was convicted under it for not following the Attorney General's regulation. The Attorney General regulation did make it applicable to most, if not all, almost all sex offenders prior to the act's passage. And the only issue the Supreme Court took was whether that level of broad delegation to the Attorney General to decide who the law applies to, who that crime applies to, without any guidance is constitutional. Now, lawyers in the room and the law students in the room and those on public access TV might be interested in the following additional fact. There are 12 judicial circuits. 11 had, all but the DC Circuit had upheld the delegation. And for the Supreme Court normally only takes a case if there's a split in the circuits. The fact that they took it is rather telling. And one of the circuit courts that upheld it is the 10th Circuit, and then now Justice Gorsuch, dissented from rehearing in that. Dissented from he wasn't on the original panel, dissented from the full circuit hearing the case. So we kind of know where he is on this. And listen, if you're a betting person, I don't know there's a way to bet on the Supreme Court cases lawfully, but maybe there should be. But I think the betting money is on the Supreme Court reversing. But there's 4 basic positions that the Supreme Court could take in this case, but I think they will all result in a landmark ruling for different ways. The first position that no one in the case argues and no amicus argues is that the court should announce they're not going to enforce this rule. There's a few academics who argue that. Justice Stevens, no longer on the court, once argued that. They don't necessarily say the delegation rule is not important, but the judges just should do nothing about it. That's not, the court justices are not going to embrace that. No one embraced that. But I'll tell you why that is a unfortunate and improper result. Anyway, consider the Fourth Amendment. The Fourth Amendment standard is that the police shall not engage in unreasonable searches and seizures. Normally they need a warrant beforehand, but the touchstone is unreasonable search. That isn't a definite standard. It's hard for the courts to apply. It's sometimes subjective, sometimes circular. There are 50 cases on when searching a car is reasonable and when it's not. There's 100 cases on searching a home is reasonable, not when you need a warrant, when you're not. But the courts don't abandon the job of doing that. Nor do they come up with lax doctrines that always allow the police to get their way. They don't come up with a doctrine that says, as long as the police officer who bust down your door and rifled through your stuff had an intelligible principle, that's okay. And by the way, the intelligible principle would always be, I'm searching for criminals. You know, they don't do that. It would be terrible if they did that. What they do is they do the hard work of, there is no bright line rule in the Fourth Amendment. It's called a case-by-case adjudication. So they decide 100 cases every few decades, and we know there will always be hard cases. And in law school, sometimes you study just the hard cases, and it makes you think that every case in the law is a hard case. And on TV, every case is hard, and it seems that all cases, no. There are hard cases. They're the most interesting ones. But what that means is there's easy ones on either side. What it means is if it's a close case, whether the police can search your car if you seem to be high on pot or different things like that, then it's an easy case that they can't do it without a reason. And so the judge is doing the hard work of keeping the police in line, obviously encourage the police to behave even better. So what would happen if the police, by the way, the same is true in First Amendment litigation. First Amendment doesn't have clear lines. There's a lot of different exceptions, but what the courts do is they look at every fact and after they establish 10 in a particular area, you kind of know that on this side, if you're far from the line, you're unconstitutional. If you're far on the other side, you're probably just because a doctrine is hard. And that was one of the primary excuses my former hero Justice Scalia gave for not enforcing the Delegation Doctrine isn't an excuse for the courts not to do so. Well, Justice Thomas and Justice Gorsuch have been pretty outspoken in saying the courts need to do more. And at oral argument, the justice seemed engaged, and most of them seemed to want to do more. So I mentioned the first possible position is the court would announce that they're never again going to enforce this. They'll drive a stake through the heart of the delegation doctrine. That's not going to happen. Okay. Position number 2 is that the United States wins. And the United States argued that the statute that delegated the power of the Attorney General had an intelligible principle, and the intelligible principle was that the Attorney General should go as far as possible to cover pre-act offenders. The only problem with that is there really isn't much support in the legislative history. I won't spend a lot of time on that. I think the Solicitor General did a great job of trying. That's what lawyers are paid to do. But the actual more persuasive legislative history argument is the House wanted to apply it, the Senate couldn't agree, and they punted. And so I think there is no intelligible principle in the statute. Okay, so the last 2 positions are the most interesting, and they're the ones that all the amicus supported. And my organization filed an amicus brief, but there are about 8 groups that filed asking for a narrow ruling. And the ACLU's brief is a good example. So if you want to read one of the briefs that takes this narrow view, you might look at the ACLU brief. And what they say is the SORNA delegation should be struck down, but we should come up with some way to limit it only to, they don't say only the statute, but only to criminal law statutes that delegate criminal law power to the Attorney General that the Attorney General then defines. And I'm trying to be fair to it, but our position, and the position of about 8 other amicus groups, and I think the position that Thomas and Gorsuch and maybe Kavanaugh, but Kavanaugh's not going to vote in this case. He didn't hear it unless it's re-argued. If you want to know why, I'll tell you later why I don't think it's going to be re-argued. I think we are going to get 6 justices or so that are going to strike this down, but maybe for different reasons. But we believe the non-delegation doctrine needs to be fully and fairly enforced by the courts. Like the First Amendment, like the Fourth Amendment, it may be tough, but that's your job. And that it should apply equally to civil law and to criminal law. And let me tell you a few more reasons why I think that our position is more consistent with the Constitution than the minimal position. For one reason, the distinction that SORNA is a criminal law doesn't really distinguish it from many of the hundreds of other laws that I'm concerned about. Many of the other 100 laws delegate power to administrative agencies to write rules, and there are criminal penalties for the violation of them too. So if we're concerned about, if we have special concern about delegating power to administrative agencies to define crimes and then enforce crimes, we should be equally concerned about delegations to the regulatory agencies. And Justice Kagan, who seemed to be on the government side, was pointing out that that criminal, non-criminal distinction didn't work. So I may disagree with her outcome, but she was absolutely correct to point out that you can't distinguish this statute from another one. Now, the result should be you should strike down this one and signal that others are at risk too. The second reason why I don't think this limiting the case to just this statute will work is that the Attorney General doesn't enforce his own regulations or her own regulations when it's a woman. Assistant U.S. attorneys or line attorneys in the criminal division enforce laws both that the Attorney General issues and that, let's say, the EPA administrator issues. And the U.S. Attorney, I don't think, gives any greater weight to criminal provisions that, you know, his or her boss, the Attorney General, issues than the EPA administrator. And in fact, the provision at issue in the Gundy case demonstrates that. It's clear that it applies to Gundy. There's no interpretation. The assistant U.S. attorney who brought that case didn't read it broader to cover Gundy because it was the Attorney General. No. Everyone agrees it covers Gundy if it's lawful. But the EPA's regulations under the Clean Water Act or something like that are impossibly more complex. And the risk of a U.S. attorney, interpreting that broadly is actually greater. third, one argument that the ACLU and other amicus on that side made to limit the doctrine to that is that the other regulatory agencies have expertise and the Attorney General does not. But that's not so. The United States actually defends the SORNA delegation on the ground that the Attorney General was exercising expertise about what was practicable. And so by trying to distinguish the delegations to the other regulatory agencies, they actually risk losing the Gundy case. And I think that's not serving their clients very well. There are a few other reasons to think that really reinvigorating the delegation doctrine is the right call, but I'll just mention one other thing in the Pacific Legal Foundation brief. Ours is the only brief, I believe, that actually told the Supreme Court what rule it should apply. At a minimum, about 8 of us argue they need to give their old intelligible principle test its teeth back. From 1928 to 1940, at least it had some teeth and was doing some work. But we suggest another doctrine that's based in another case from Chicago, actually, should be applied in this area. It's the void for vagueness doctrine. The void for vagueness doctrine says if a city council, just to use the example from Chicago, passes a vagrancy law, but then doesn't define vagrancy and leaves it to the police to define what, then that's unconstitutional. And there's 2 reasons for that. One is it doesn't give fair notice, but the Supreme Court also just says is it needs to be defined by the legislative body. Well, that same principle should apply to rulemakers at the federal level, rulemakers in the agencies. And so if the Supreme Court, the void for vagueness doctrine doesn't have clear rules. The Supreme Court just correctly decides when something is too vague, when it does give too much discretion to the police officer. That same rule should apply to rulemakers. So with that, I'd like to take your questions. Who has the first question?
Christian has class.
I do have a question. That is, would a full enforcement of the non-delegation doctrine apply at the fullest extent to the courts being unable to substitute the role of Congress? Or is that discrete from the subject?
It might lead them to kick things back to Congress a little bit, I think, but mostly the non-delegation doctrine applies. By its own terms, it applies to delegations to the court, but usually when they rewrite a statute, they're not told to rewrite it, they're just sort of doing it on their own. Whereas the executive branch agencies where the delegation doctrine applies in full force are expressly given some power to define, to fill out the gaps. And again, we shouldn't object either judicial or executive if they're tiny gaps. And no matter how smart Congress is and detailed Congress tries to do, there will be some gaps. But I agree with the thrust of your question that the court too often tries to fix statutes by effectively rewriting them, when what it should do is it should say the statute is unworkable or unconstitutional, especially unconstitutional, and they can do it again. They can do it again. Now, if the Supreme Court did that in either the delegation context or the other, Congress would become disciplined again. They've been encouraged, they've been incentivized to be sloppy. Yes, ma'am.
A more general question. I'd like your opinion about whether this issue has become so much more important because of the fact that, in general, government is doing so many things in so many arenas that Congress doesn't have the capacity to follow through on all of these different areas that the government's involved in. I mean,
I'll repeat the question. Is this, and tell me if I've,
okay.
Just for the recording and for the television audience, has this issue become more important because the scope of government has become so much larger? And I definitely agree, and I'll explain. But then the last part of your question, I somewhat disagree with. And I think you said, and because it's necessary for Congress to delegate more. That's what's a little more controversial. So let me try to answer both. Certainly, I think the problem has grown because Congress has delegated more, and quite frankly, a lot of that is questionable whether the government should be doing it at all. The assumption that if it's important, the federal government must act on it is more of a philosophical belief than an empirical one. The framers understood that the states would be the primary sovereigns and that the states would be primarily govern our lives. And there was certainly a time when the states were horrible in civil rights. But I don't think that's true, that states are uniformly horrible in civil rights today. And the federal government has a role to make sure they're not. But in many, many other areas, I think states are what other justices have said are the laboratories of democracy, and we should let states do more. So just because it's an important problem doesn't mean it's a problem for the federal government. But there is an argument in these 1940 cases where the Supreme Court allowed broader and broader delegations, where they said it's necessary for these areas where the federal government should be involved for us, for modern technological society, for us to delegate to the agencies. There was this I think, disproven notion that the experts in the agencies were neutral. They're not neutral. They have their own politics. They favor bigger government. What's the most important motive? You know, anyone who goes in the government, I was a government servant, and it's an admirable thing. But if you go commit yourself to a particular agency for all your life, then that's the most important thing there is, right? And the most important thing to do for your agency that you believe in is make it grow and make it more powerful. And the framers understood that would be the tendency, and that's why they wanted the people who actually wrote the rules that govern us to be kept to the most accountable branch. But I think modern scholarship has shown the idea that Congress can't do a better job is false. That, for example, could you really imagine that Congress can't do a better job of regulating the internet, if it's going to regulate the internet or not, than in the public interest? Is that really required for modern? By the way, the market can also provide regulations of itself. There can be tort remedies for companies that injure us. We do not need a central rule for everything. In fact, a central rule for everything stifles innovation. And so the modern scholarship is showing the more, by the way, agencies tend to become more and more detailed over time, more and more encrusted, more and more sclerotic, more and more stifle innovation. So the modern scholarship suggests that less regulation is probably better for the economy as long as there's a floor, and Congress can provide that floor. On the other hand, I'll answer a kind of related question, which is what can Congress delegate? There are certain facts that Congress can delegate. So if Congress says, here is the standard for pollutants in the water, and actually decides what the level is instead of allowing an agency to decide the toxicity level or whatever. There are certain things, and then they say, okay, we defer to the agency's scientific fact-finding as to whether benzene or lead or whatever, whether certain concentrations meet the standard that we've set. And when you find that, we're going to tell you what to do about it. You shall then outlaw it or regulate it, and these should be the fines. So Congress can certainly do more, but still leave a fair amount of room for agencies, but agencies would be engaging in fact-finding. Now, that doesn't mean that fact-finding is devoid of all political judgments, but Congress should be minimizing the political judgments. We want them to make the political judgments. That's what the framers wanted. And we can then vote them out of office for their political judgments. We want the agencies to be engaging in science or fact-finding and enforcement.
So I know that this is specifically about SORA, the Sex Offender Registration Act, but if I'm hearing this correctly, if, let's say, it goes the way of revitalizing the non-delegation doctrine, I guess what would be the next stage? Someone bringing a suit against some agency that sets regulations, polices the regulations, investigates them, prosecutes them, adjudicates them?
Wouldn't that be great?
Okay,
Yeah.
so I'm on the right track. That theoretically could happen,
Yeah.
if it goes that way
Yeah.
of getting rid of SORA.
Again, let me try to repeat your question a little bit again for our viewing audience. This case, you're correct, is about more than just the Sex Offender Registration Act. There wouldn't be 16 or however many amicus briefs if it were just about that act. And there wouldn't be as much coverage in the legal press. And you wouldn't invite me to speak if it was just about the Sex Offender Registration Act. It's about this constitutional principle the court has said is essential, but the court hasn't enforced. And the justices at the Supreme Court were very conscious that it was about a broader issue. Justice Breyer expressed concern that it could affect 300,000 regulations. I think that's overstating it. Now, 300,000 regulations exist, but I don't know how many of them are issued pursuant to an overbroad statute. But let me return to what the likely outcome is. Again, I think maybe one or two justices will vote to uphold it. This is just a guess. Lawyers have often been embarrassed guessing based on oral argument. I think there may be 3 or 4 justices that adopt that narrow position out of fear of overturning too many precedents. I think they ought to do what's right under the Constitution, and yes, precedent has its place, but this isn't one of them. I think they should announce the right principle and then let the case-by-case adjudication. The second part of your question is, how would these subsequent cases come to the court? Let me finish by saying 2 other justices, Thomas and Gorsuch, might either join in the opinion that the other justices that are narrow and say that in a different case they would go further, or they may not agree with the reasoning and they may just concur with the result of striking down this, but say the court should go further. Either way, as long as they strike down SORNA, even if they try to limit it, I'm going to be jumping up and down with joy. And the reason is because it's at least a baby step to enforcing this vital constitutional rule. And I think any attempt, I gave you some reasons why I don't think the narrow approach fits. So even if the justices try to limit it to just cases that begin with S and end with A, they won't do that, but you know what I mean. Try to define it. Their reasoning won't be able to be cabined, because if their concern is delegating a criminal law power to an executive branch that's going to enforce it, that's true of all these other laws. So the way the law evolves is the Supreme Court announces its principle in this area, and then, yes, we at the Pacific Legal Foundation bring the next suit. As I said, we've brought 4 this year. But many other people who are oppressed by regulations that were written by bureaucrats who aren't politically accountable under broad statutes will bring theirs, and there will be a case-by-case adjudication. Now, how many of those would win? Well, there was one amicus brief by the Institute for Justice that I'd also recommend. Our friends at the Institute for Justice are also another wonderful libertarian public interest law firm. And they pointed out that roughly 12 to 16 constitutional law challenges in different areas succeed. Well, does that depress you? That only 12? No, maybe that's about right. But if no one is litigating, maybe most people who bring a Fourth Amendment challenge lose. But it's good that 12 people win, 12% of Fourth Amendment challenges win. That helps keep the criminal justice system honest. It's good that 12 to 16% First Amendment cases. And the other interesting thing about that brief is they pointed out that states have non-delegation rules too, and that states vary in how effective they are, but approximately 12% of non-delegation challenges in the states succeed. That's about the same as First Amendment challenges. It proves that those states haven't fallen apart. It proves that those states' government doesn't, but those states' legislatures are more disciplined than our Congress. Our Congress now has zero discipline on this delegation rule. They are not scared. It's been 85 years, and the message from most law schools for most of that 85 years is it's just a pretend doctrine. It's just a pretend threat. It's on life support. It's not going to be reanimated. Well, this is Halloween, and so let's get our electric probes together and let's root to animate the delegation doctrine, because like the First Amendment and like the Fourth Amendment and like our other constitutional protections, they protect our liberty, and we need to insist on the courts at least beginning to draw the line. So if I was predicting, they won't go as far as I think they should, as the court should, but any step in the right direction will encourage people like me and our organizations who litigate in the public interest to bring further challenges. Now, how many law? I don't know. If 12% of our, by the way, I'm not going to challenge every one of those 300,000 regs, but I'm going to we may try to challenge a lot of them. And if 12% of them succeed, then Congress will have some work to do. But that's a great thing. That's not something to be afraid of. What that means is that the Constitution will be honored.